All right. Good afternoon, everybody. This is Eric Hauge, Executive Director at Homeline, and we're joined by Housing Attorney and Research Director Samuel Spade. And today is Thursday, July 2nd. It's 1:30, and you're joining us for Homeline's weekly webinar on COVID-19 related housing and rental legal issues. We've been doing all these every week since mid-April. Reminder, Homeline is a statewide nonprofit organization. We provide our main program is a free and confidential legal hotline for renters throughout the state to get answers to their legal questions that impact rental housing. And we advise folks in English, Spanish, Somali, and Hmong languages. And we've been doing these webinars again since mid-April every week to just provide a venue to share information, generalized legal information, and guidance around rental housing issues related to the COVID-19 pandemic, the eviction suspension, etc. Every week on Thursdays for this audience of landlords and property managers. And Wednesdays, we do one targeted more for tenants and service providers. Again, today, similar to previous weeks, we are going to do a brief overview of some of the most common questions related to the eviction suspension here in Minnesota and nationally. And then, like we did last week, provide a little bit of an estimate and information about our thoughts on the potential impact of upcoming possibility of evictions throughout the state, sharing some more focused local data in Hennepin and Ramsey. And then we have plenty of time set aside for Q&A if folks do have questions. We did get a handful of questions submitted in advance that we'll get to first after the overview, and then happy to answer questions via the Q&A submission tool on Zoom or over the chat. So with that, I'm going to hand it over to Samuel Spade, Homeline Housing Attorney and Research Director.
Hello, everyone. So as Eric said, my name is Samuel Spade. I'm one of the staff attorneys here at Homeline. And we're just going to go over a couple of things here. Primarily, in the slides, we're going to talk about the moratorium and the various things that affects, what it covers, how it ends. And then we're also going to talk a little bit about the number of evictions that we could expect to see during or once the moratorium is lifted. And then we have a number of questions, as Eric said, that we've already received, and we'll answer those. And if there are more questions, we'll try to answer those as well. So let's start with the two types of moratoriums on evictions in Minnesota right now. There are two levels of this. The first level is the state level. That is put into place by the governor's executive orders. There's two particular ones that come into play here. The first is the peacetime emergency declaration. That does not specifically list any of the lease termination restrictions, but the second executive order is the lease termination restrictions or moratorium, and that is tied to the peacetime emergency. Essentially, it says that it is in place for as long as the peacetime emergency is in place. So the lease termination or eviction moratorium really covers more than just evictions. It covers evictions, it covers them for basically all categories, so that includes non-payment, staying past the notice to vacate, which has some other things which we'll talk about, and breach of lease. About the only thing it allows evictions to go forward on is a couple of crimes, the crimes that are listed in Minnesota Statute 504B.171, those being illegal drugs, illegal guns, engaging in prostitution, or possession of stolen goods. And so it's not even all crimes, it's just those specific crimes, and then acts that substantially endanger other people. And that's a little bit vague, but it would probably include anything that was, dangerous to or could cause harm to another person if that harm was serious. It also, though, prevents lease terminations. So it's not just evictions, but normal lease terminations, such as a 60-day notice from the landlord to the tenant on a month-to-month lease or at the end of a 1-year lease are also prohibited. It does not prohibit tenants from giving notice or from tenants agreeing to leave. So it's not like a freeze on tenants moving, but it does prevent landlords from forcing tenants to move unilaterally through, again, the eviction process or a notice to vacate. That's at the state level. Again, that was put into place sort of through the 2 governor's executive orders, the peacetime emergency and then the actual specific one that prevents lease terminations. To add on to that, the Attorney General is enforcing the lease termination prohibition. So they have set up a specific complaint a form on their website that tenants can go to precisely for this issue. A tenant can go to the website, they can say, my landlord is taking the following steps to try to terminate my lease, and the Attorney General might in some cases, and actually has in some cases, go after the landlord, press charges. It's a crime to violate the emergency order, so the Attorney General could press charges. In most cases, what they do is they call the landlord and they tell the landlord to back off. They tell the landlord that what the landlord is trying to do is in violation of the the executive order. And if the landlord does, then that is normally going to be it. But in more egregious cases, like I said, we've actually seen the Attorney General press charges. And you can look this up on the Attorney General's website if you're curious to see what the form looks like or some of their other actions. Eric, I think they actually posted publicly a couple of the times that they brought charges. I don't know if you could maybe post those links if they are public. The way the Minnesota moratorium would end would be if the governor ended it, either by just ending it or not extending it, or if both the House and the Senate voted to end it. Currently, the Senate has voted to end it, but the House did not. And my guess is it will stay that way for the foreseeable future. Maybe if things change, with how the coronavirus or COVID-19 is going, maybe that'll be different. It's set to expire on July 13th, but it has already been extended by the governor 3 times. And again, unless we see a significant change in the progression of COVID-19 in Minnesota, and probably to some extent the rest of the United States, I personally, and this is not official at all, but I personally would expect it to be renewed at least one more time, unless there's a change. However, we don't actually know that. It is up to the governor, and at least historically, over the last 3 months anyways, the governor has been waiting until roughly the last day or the few days before the expiration of the peacetime emergency to extend it, most likely using that time to rely on all the newest and freshest data and to make the decision based upon that. And then there's also the federal prohibition. The federal prohibition is a little bit different than the state prohibition. The federal prohibition only applies to non-payment evictions. And non-payment evictions, so it doesn't apply to all lease terminations, but it applies to non-payment evictions. Started, I believe, March 25th, and it goes through July 25th. And it doesn't allow landlords to file evictions on July 25th either. It says that on July 25th, the landlords can start giving a 30-day notice to terminate the lease. So what it will actually do is extend the time for when evictions can be filed through essentially the end of August. It does not apply, though, to all landlords. It applies to all landlords that are taking various government subsidies for the housing, and then it applies to landlords who have federally backed loans through Fannie Mae or Freddie Mac. So landlords, of course, presumably, if you're the owner, maybe not if you're a property manager, but if you're an owner, you would know, hopefully, where your loan is from. You'd be able to look that up and see if it applies to you. There are some databases out there that people are creating to try to document this and get this information out to tenants. And we've been told that at least some of the counties in Minnesota, I'm not sure if they're all doing it or if it's just some at this point, are requiring or are going to require landlords to say that the CARES Act does not apply to them in the event that the Minnesota peacetime emergency ends before the federal CARES Act does, and landlords would be allowed to file under the Minnesota, or without the Minnesota moratorium, landlords would be allowed to file. But then if it's for non-payment, they're going to be required, again, in some counties, not all, to show that the CARES Act doesn't cover them as well. And so certainly if you are the owner, the landlord, understanding whether or not this would apply to you would be a great thing to do if you were seeking to file an eviction. Certainly this is the type of thing where consulting an attorney on your specific issue would probably be a good idea. And again, that's the federal prohibition. I am not aware of anything about extending that, but there might be some ideas for extending or adding to that on the federal level as well that I'm not aware of. So over the last 5 years, over the last 5 years, there have been about 16,000 evictions filed each year. However, when we look at that number, that is the total of all evictions. So it's not just residential evictions, it's commercial rentals. Evictions are also the final step in the foreclosure process. Rarely there can be contract for deed evictions as well. So that number is actually higher than the total number of residential evictions. And actually figuring out residential evictions is very tough. Certainly you can look through and exclude, evictions filed by banks on the assumption that those are probably going to be foreclosures and homeowner processes, but some of those might actually be for tenants as well. You can look for cases where the eviction, the defendant, the tenant, is a business name, and you can assume that those maybe are commercial evictions. But there are going to be a lot that slip through. So it's very difficult to get an exact estimate. The only way to actually do that would be to look through the actual complaint of every eviction, and obviously no one has done that or is going to do that most likely. But our best guess, doing some of the more general sort of reductions, is that there's about 14,000 residential evictions filed each year on average over the last 5 years. And this translates to roughly 1,100 evictions per month statewide in a normal year. And then we looked at, for this presentation, we looked at evictions in Hennepin and Ramsey specifically, and we also limited it to the months of May and June, and from 2015 through 2019. And the reason we did that is evictions are also a little bit seasonal. They ebb and flow depending upon which month we're in. So over the summer, especially July, August, September, there can be a lot of evictions, and then they start dwindling. December is one of the lowest months. January, it goes up again, presumably because there's a little bit of holdover from the December evictions, and then it's pretty low for the rest of winter, then it starts to come back up over the summer. And so looking at it just for this time frame in Hennepin, there's about approximately 400 evictions filed each month, and in Ramsey there's approximately 200 evictions filed each month. And so when we are thinking about how many evictions will be filed once the moratorium lifts, these are some of the numbers that we're looking at. So the eviction moratorium started in mid-March. And so there are going to be some tenants who haven't paid rent since March. On top of that, the Minnesota unemployment rate, because of COVID-19, has gone up. It's approximately 5% higher than it was last year. And while most tenants have paid, some, obviously, as we've said, have not, and many tenants are able to pay because of the various forms of financial assistance, such as unemployment and the stimulus checks that have been sent out. Those things are set to end currently at July 31st, so if there aren't some extensions or new procedures out there or more financial assistance, it could become harder for tenants to pay, and the fact that most tenants have paid, that might change a little bit once some of these things go away. Another piece of data that we're looking at when we think about how many evictions could be filed once the moratorium lifts is Minnesota multi-housing. We don't have any special inside track, but they did report it to a newspaper that reported on it earlier this month. And as of June, so this was almost a month ago now, but as of June, their numbers were that in the newest and most expensive rentals, 94% were current as opposed to 97% last year, which was a 3% decrease. And then there was a 1% decrease in the slightly older units and a 4% decrease from 92 to 98% in the most affordable places. And an important thing to note about these numbers is that, you know, going from 97% to 94% doesn't mean a 3% increase in evictions. If those were the only things that we are looking at, and evictions were filed for every single tenant that was behind on rent, and we'll talk about whether or not that's a good idea or whether or not that will likely happen. But if that was the case, that would actually be a doubling of evictions filed for the most expensive units, and about a 30% increase for the most affordable, with not much of an increase for that middle rank. And again, we'll see how this changes when we get to July. So again, just looking at the numbers, we had a 92 to 97% delinquency rate last year and an 88 to 94% delinquency rate this year. And you know, if that's not just a 6 to 12% increase in evictions, that could be as much as a doubling in evictions for that time period. One important thing to note, though, about this data is it does come from Minnesota Multi-Housing. Our understanding is they were simply polling their own members, and their own members are probably not representative of well, they're almost certainly not representative of the entire state, and they're probably not representative of certain categories of housing or apartment complexes, sizes, etc., even in the metro area, or, as I said, around the state. So you have to take those numbers with a grain of salt. The situation could be better or worse than is just affecting Minnesota multi-housing members. So the next thing to think about when we're thinking about how many evictions will be filed is to think about the courts. So if landlords file evictions, our assumption is that they will probably file sooner rather than later. That could be a lot of cases in, for example, a single week. Maybe it'll be more spread out than that. There's not a lot of ways to know, as nothing like this has really happened before, but there are probably a bunch of bottled up cases. And if the landlords go and file it, again, they'll probably file pretty quickly. So as of this presentation, April, May, June, and July have all been affected. So if the moratorium went in place in March, presumably most tenants already paid for March, but maybe there would be some evictions. Actually, we know that there are some evictions that were for March's rent that were caught in that moratorium because they were filed a little bit later in the month. But mostly you're talking about April's rent, May's rent, June's rent, and July's rent now. During the average week pre-COVID, there were about 270 evictions, or as we said, it's about 1,100 per month. About 400 per month in Hennepin and 200 per month in Ramsey. And so that's a lot of court cases that have not been filed during this time period. It's probably about 4,500 court cases. Again, not all residential evictions, but about 4,500 court cases that have been held up. If they were all filed immediately, that would be a huge increase in how many cases the courts had. Now, they're probably not all going to be filed immediately, though, because, as I said, the CARES Act extends through the end of August, effectively, which means that at least at present, if the moratorium were to end on July 13th, as it's currently set to, and is not extended again, you know, a significant number of evictions still could not be filed because they'd be under the federal protection. This number might change, of course, if the state continues to extend the eviction moratorium. So this, and the number, of course, will go up. So if the eviction moratorium is extended through mid-July, or not mid-July, mid-August, then we'll be looking at, say, a little over 5,000 or closer to 6,000 eviction cases that have been skipped. However, there are also other things that influence this, such as people receiving payment plans, making payment plans, receiving financial assistance, and so on. And again, when we're looking at the numbers from Minnesota Multi-Housing, you know, they may be showing in some cases up to a doubling of people behind on rent, but a doubling of people behind on rent is not the same as a quadrupling of people behind on rent. So it will be difficult to see how many people, just because someone was behind in March, for example, or April, doesn't mean that they are still behind if they've been able to get back to work or got unemployment or something like that in the meantime. So will landlords actually file evictions for tenants who are behind on rent. Many, of course, will, but there is sort of a cost-benefit analysis that every landlord has to go through. As the audience in this presentation is mostly landlords, I'm sure you're all aware of this, but winning an eviction does not mean that the tenant has to pay you money. You might get a judgment for court costs, though that doesn't always happen either, but you're not going to get a judgment for the money that the tenant owes. If the tenant owes for several months, that tenant might owe it to you, but the eviction case isn't going to give you anything that will allow you to collect it. You can, of course, report it as a debt in many cases, or maybe take it from the deposit or sue the tenant in conciliation court. But if the tenant doesn't have the money to begin with, actually collecting it might be difficult to impossible. So there is at least a strong incentive for landlords to allow the tenants to stay and work out a payment plan, allowing landlords to recoup some of those rent whenever possible. Because the tenant who can get caught up on, say, 2 to 3 months worth of rent is a lot better deal, at least from our perspective. It's a lot better deal for everyone than the landlord being able to force that tenant out and then find a new tenant who might be more prompt in paying or not, depending upon what happens with COVID-19. The landlords would be taking a chance with any new tenant as well. But just having that debt sit out there for who knows how long versus working with the tenant to set up a payment plan. So our hope is certainly that landlords will be working with tenants, and that tenants will be working diligently as well to get financial assistance, to make payment plans that are reasonable, and solve those issues. So one thing I want to note about payment plans is that a payment plan Homeline sees a lot that does not work is tenant pay 100% of the money owed in the next week or the next 2 weeks. So we see these settlements made a lot in eviction cases. They have very, very high fail rates. And so when we're talking with tenants, certainly one of the things we tell them to do is consider carefully how much is actually realistic for them to pay back. Paying back the money over several months is generally much easier to do than paying all of it in one lump sum immediately if the tenant, especially I should say, if the tenant is not able to find any type of financial assistance to cover that. If a tenant is behind for several months, it would be difficult, in most cases impossible, to expect the tenant to pay everything in 1 week. Whereas it might not be the case, where they might be able to pay it, I should say, if they were given more time to do so. And so we certainly tell tenants that when working towards making a payment plan, they want to be honest and realistic about what they can afford. And they want to think about how they can actually pay and how much they'll be able to pay in order to get caught up. And actually, I should say one thing before the question and answer. I meant to say this on an earlier slide and I just forgot. But one of the things that we also want to think about in thinking about how evictions are going to work once the moratorium is listed is the time frame of how quickly they can be filed. So landlords will maybe file them very quickly. But the standard process, again, as I'm sure most of the audience here knows, is that the eviction process takes about 20 days. The court will generally hear it, or has to, or is supposed to hear it within 7 to 14 days. On average, especially in the metro area, that's 10 to 14 days out from when it's filed. At that point, a tenant can ask for another 7 days if they lose. If it goes to trial, it gets extended even farther. And even if the writ is issued, the sheriff has to wait 24 hours to enforce it. That's all pre-COVID. Many of those timeframes have actually been relaxed. There's some state orders that say courts don't have to process the cases that fast. And when you think about the volume of cases, if Hennepin County, for those who have certainly been or observed how quickly cases go through in Hennepin, they do go through pretty fast. Some might say too fast, but they go through pretty fast. But if the Hennepin volume gets doubled, tripled, or quadrupled, they're not going to be able to process the cases in the same time frame that they used to. And that's going to be true for many other counties as well. So I would expect to see long delays in how long or how fast the eviction goes through the process. And even once the sheriff is enforcing it, the sheriffs actually have to go out and enforce the writ. Currently, they already wait some amount of time and generally schedule it for certain days, at least in some counties. And if they get overwhelmed with the number of writs they have to enforce, they may also experience delays from posting and enforcing those writs as well. So there could be delays on both ends. No one knows, and I'm certainly not going to predict how long eviction cases will take, but my guess is it's going to be at least, it's going to be significantly longer on some level. All right, and with that, I think we are to some of the questions.
We are. Thanks, Samuel, for the overview. And so we did get a handful of questions in advance, and we'll start with those. But please, at any moment, feel free to submit your question via the Q&A box or via the chat, and we'll get to them. We have plenty of time, but we don't have to take all the time if it's not needed. All right, so a couple questions that were written in advance by Kimberly. First one, we have several tenants who are not paying rent due to the pandemic. We have had several air conditioner units go out and they need to be replaced this week. One of the units is one of the air conditioner units that needs to be fixed is in the unit of a tenant who's not paid their rent. The rest have paid their rent. The problem arises that with some tenants not paying, our cash reserves have now been deleted and we don't have the money to replace the units at $5,000 each. Air conditioning is not written into the lease. What are our options?
Sure. So one thing I want to clarify before answering questions is while we are going to answer questions, I'm going to do so generally, and it is very important to understand that the answers are not legal advice. We're just answering it from these very simple fact statements that are sent us. I mean, we've got just a couple sentences here. This is not enough to give a complete answer on a specific question. Certainly, if you have legitimate questions, especially if you're intending to take any type of court action, you should be seeking legal advice from your own attorney or finding an attorney. But that said, I can certainly answer these questions generally as to how we would sort of work through this process if a tenant were to sort of give us the reverse. And so here there's a couple things to think about. The first is the AC units and AC units not being written into the lease. In general, leases don't mention all appliances. Some leases will go the extra mile and will, but most do not. And so the standard rule is that a lease or a property has to be fit for the use intended. That's actually state law. Every lease is expected to be fit for the use intended, kept in reasonable repair, maintained in compliance with the city health and safety standards, etc. And so with appliances, generally, if they were there when the tenant walked through, or if they were a part of the unit, they are included. Or to put it another way, all our opinion at HomeLine is that all appliances are included unless the lease says that they're not. And then in that case, maybe they won't be, and there are probably even certain appliances you can't exclude, things like stoves, refrigerators, etc., many of which might even be required for code compliance in some cases. But dealing with an AC, if a unit comes with an AC, that's part of what the tenant is getting when they pay their rent. And so that's something that has to be maintained under state law. At least that is how we would generally phrase it at HomeLine. Then the question comes with, well, does it have to be repaired? Not having money to make repairs doesn't generally, in fact, in most cases, I would say just categorically does not allow a landlord to escape their burden to do repairs any more than losing a job or something like that would allow a tenant to escape their burden of paying rent. These are things that are essentially obligated under the contract and under state law. And I mean, they've been litigated in court as well. The landlords have to make repairs regardless of their money situation. And if not, the tenant will have various recourses. One of the most common recourses is the ability to either withhold rent or receive a rent reduction because repairs are not being made. There's a case that's pretty old now, but has been repeatedly affirmed at various levels, including at the Supreme Court recently. If repairs are not being made, some or all of the rent is not owed. So how significant an AC is with regards to what portion of rent would be refunded for a broken AC is a question I think that would be decided by either a court or a jury, but certainly some amount would probably be awarded to the tenant. Now, from the tenant's perspective, actually forcing a landlord to make repairs requires them, if they want to go the full length, to file a court case. There are a couple of different court cases. There's the emergency tenant remedies action, and there's just a standard rent escrow. The thing about the rent escrow is that it does require the tenant to pay the rent owed into court, which means that a tenant may not be able to file a rent escrow if they're not current on rent. Tenants are allowed to file emergency tenant remedies actions, though, if they're not current on rent. So it would depend upon whether or not the AC qualified as an emergency or not. We have seen ACs qualify as emergencies in a number of different scenarios, and that's always going to be up to a judge. Certainly, if there's any medical issues or anything like that, the chance that it gets treated as an emergency by the court goes up significantly. And even if the tenant can't file the rent escrow to force the repair because they're behind on rent, and it doesn't qualify as an emergency, so they can't use that option, they're still going to be able to ask for a rent discount. So not making a repair in a case like that could very easily decrease the amount of money that the tenant ultimately owes when they're trying to get caught back up. That would be how I work through that problem. Again, this will be the last time I repeat it, but in all these cases, if this is a real issue, it should be discussed with an attorney because there might be additional facts. We're just looking off of a couple sentences here. Eric, do you want me to read the next question here?
No, that's all right. I can do it. Sorry. Multitasking. Kimberly has another question. We have a tenant that has been in the house for over a year who said that she saw a mouse, wants that to be dealt with. The landlord said it was our understanding that once the tenant has been in the house more than 60 days, it was the tenant's responsibility, and the landlord said buy a pack of traps. Tenant's now saying that it's required under Section 8 that the landlord is required to do it. Can you shed some light on this, please?
Yeah, there's certainly nothing in state law that would allow or require a tenant to be responsible based on some type of time frame for a repair issue. That's not going to matter at all, whether it's day 1, day 60, or the last day of the lease. Maybe what the landlord in this case was getting at is that landlords are not required to fix problems that are the tenant's fault or that the tenant created. And the argument might be from the landlord that after 60 days, they think the mouse is the tenant's fault. That is certainly possible in some cases, but I think in all cases, the landlord would actually have to prove that it was the tenant's fault. So take, for example, a drain, which I think is a little bit clear. If on day 1, or while the tenant is moving in, the toilet clogs, it would be pretty hard pressed, or much harder at least, to show that the tenant was somehow responsible because they've barely been there, barely done anything. Whereas 60 days in, if a drain clogs, due to something going down the drain that shouldn't, it's maybe a little bit easier to make that argument, or at least more possible to make that argument. But in both cases, the landlord would actually have to make it and actually prove it, that the tenant was the one who was responsible. And here, I don't know if, honestly, if I would take the same course with mice. It seems like mice are probably not really that contingent upon how long a tenant has been there. Maybe there's some facts I don't know about mice that I'm missing, but again, that's sort of how we would analyze it.
Right. One more from Kimberly. In hopes of working with tenants who are unable to pay the full amount of rent each month, we'd like to accept partial payments. We've had some success with tenants signing agreements of a payment plan, and that if they do not follow through, it does not stop us from evicting when allowed to do so again. What's the rule for collecting partial payments?
So with partial payments, there are a couple different rules. The first rule is that accepting a partial payment prevents a landlord from filing an eviction. This can be modified, which I'll talk about in a moment. And it's important, therefore, I think, to understand what a partial payment is. A partial payment, generally speaking, is going to be a payment of rent that means the tenant ultimately is less than a full month's behind. If a tenant pays, say, we'll just say $10 on 1,000, that is a partial payment and could prevent an eviction. Generally, it's not that, it'll be something like half, but for an example, I'll use that. However, if month 2 rolls around and the tenant again pays $10, now the tenant has paid $20 and is essentially almost 2 months behind. I would say in most cases that would not be considered a partial payment. by a court, although maybe some courts would consider it. So our general argument would be, our general argument would be that a partial payment is something that means the tenant is less than a full month's rent behind. So in a case like COVID-19, where we're dealing with multiple months, that might be different for different tenants. The next thing to know is that the partial payment, or the defense, can be waived in if the landlord gives a tenant something in writing that says they can accept partial payments and still file an eviction. This is most commonly done in the lease, but it could also be done before the tenant makes a partial payment. The landlord could give the tenant a written notice saying, we can accept this partial payment, but still file an eviction. Do you still want to pay us, only part of the rent? And I mean, the philosophy behind this statute, I think, is pretty straightforward. It's essentially sort of a waiver. It's saying, look, if you're going to take money from the tenant, but then also still evict them, you got to tell the tenant that you're going to do that, because maybe they just rather keep their money then and go to a new place. And rather than putting the tenant in the awkward position of having just given someone all their money and still being evicted because they didn't pay 100% of everything. So there's certainly, though, I think, in general, as we were talking about early, a strong practical incentive for landlords to make payment agreements, especially if this is over a long period of time, which is that, and we give a lot of landlord speeches. I can't do it here because I can't see anyone, but normally I ask landlords how often they've evicted tenants and how often they've been able to, or how often they've been sued a tenant to collect that money, and then how often they actually did collect it. And at each step, hands go down. And generally, not always, but generally, there's only one or two people in the audience who have actually both sued and then collected the rent from the tenant. And these are for smaller amounts. When we're talking about this, where there might be several months, I would assume that that number goes down even farther. And so accepting partial payments and working with tenants to collect partial payments does make a lot of practical sense, at least in our opinion. Granted, we do represent tenants, but does make a lot of sense in our opinion as far as getting that money, because if the landlord simply evicts the tenant, they probably will not be able to collect any of it. And so they'll have a debt that may be owed to them, but that debt is not going to be paid, or at least is very unlikely to be collected. And so working with tenants to set up payment plans might be a way to get that, instead of having one tenant leave and another tenant come in. And again, with COVID-19, especially, I would say that the chance that a new tenant falls into the same situation as the old tenant could be just as likely. If some other sector gets hit, if businesses close again, no one really knows what would happen.
Right. And we have one more that was submitted in advance. So Samuel's going to get to that one now, but we still have plenty of time. If there are any folks listening that have a question you want to ask, feel free to submit that right now in the chat or the Q&A. Otherwise, we might end early here. So here's the last the question that was submitted in advance from Katie. Katie has a tenant who's a caretaker, and the caretaker received a significant reduction in rent. Caretaker is not doing their duties that were agreed to in the lease. The lease has very loose language. If the caretaker, here's the loose language. If the tenant is a caretaker, the rent is $400. If they're not doing the care, they're not the caretaker, the rent is $600. The lease also states that if they do not do their responsibilities, the rent will be $600. If we wanted to discontinue this person being caretaker, is it problematic during the emergency order? Could this be price gouging?
All right. So this is one I said I wouldn't say again, but this is one I'll definitely say again. The answer to this question should not be taken as legal advice. This is pretty complicated. There could be other things at play. This you would definitely want, if you were going to take any type of legal action, to talk with an attorney about, so they could go through a bunch of the other facts that could be relevant here. But to just take it at face value and answer it as worded, Minnesota state law requires the landlord to do repairs, as I said before, but there is an exception, and one of those exceptions is that if the tenant is being compensated for doing those repairs fairly and adequately, and this agreement is in writing. Where you see this most commonly is with caretakers, where caretakers do work in exchange for a reduction in rent, or where maybe caretakers are just paid an amount of money, and then that money is maybe just automatically taken off of their rent again by agreement. Here it seems like it's the first option where the tenant is actually receiving some type of discount in rent for doing repairs. And if that were the case, and again, that's why I'm so hesitant, and this is definitely an area where there should be, you should be consulting with an attorney. But if that were it, and that were the only case, then the argument would be that if the caretaker is not doing their job, the rent is actually $600. That discount is going away, and so at that point, the tenant might owe more money. Now, the important thing to know is that all of this would still be taken care of or covered by the eviction moratorium. So even if the rent somehow went up, or if the rent did go up because they weren't doing their job, or they were fired, and firing them raises other issues of, are there any employment law issues that could come in, which again, we're not going to get into here. But the rent would go up, but they still couldn't be evicted for non-payment of that rent because of the eviction moratorium. This is also true if there was some type of an agreement that said, if the person is no longer a caretaker, their lease ends. Occasionally we see those types of contracts, or those types of terms in contracts or leases. Even that type of contract, the lease may terminate, but the tenant still cannot be evicted or anything like that during this moratorium period. As for price gouging, this particular example I wouldn't consider to be price gouging, because it's not an increase in rent. It's essentially a discount being taken away. At least that would be my opinion on it. But there are all the other issues that I just mentioned.
All right, and we did get one question in while you were answering. Sandra asks, there's no lease. What's the difference between an eviction and a termination of tenancy in that situation, I guess?
That's
written lease, maybe, I don't know.
Yeah, that's a great question, and one I probably should have mentioned in advance. An eviction, when we use the word, or when I use it, I can say, since I'm the one talking, an eviction means a court case. So an eviction, it means the actual filing of a court case with the court. They're also called UDs, or unlawful detainers. I use all those words interchangeably. Eviction, UD, unlawful detainer, they're all the same thing. They're the case that is filed with the court. A termination of a tenancy is simply the landlord, or the tenant, but in this case the landlord, saying this lease is over. The most common form of that would be a notice to vacate at the end of the lease, a non-renewal of the lease, or something along those lines. So at least that's the difference between the terminology of how we're using. Obviously, an eviction would also result in a termination of a tenancy, but when we say lease termination, that can be viewed sort of as the entire umbrella, or possibly just the notices to vacate, whereas an eviction is the specific act of filing something with the courts, saying we want to kick this tenant out. Yes, hopefully that answers that question.
All right. 2:13. I guess we can wait a minute here. In case there's any other questions, feel free to text them in the chat, or there we go. Liam has sent one via the Q&A system. What expungement rights are available to tenants in Minnesota?
That is a great question, which I am actually only slightly capable of answering, as Homeline doesn't do a lot or really much of any direct representation, and evictions can change a lot depending upon the county that you're in. So unless you're actually doing the expungements, and you're the person going to court, you might not actually know, and we don't always know what would be happening or what the court would be doing. That said, evictions certainly at this point expungements at this point can certainly be filed. There's no moratorium on tenants filing expungements. So a tenant can file an expungement motion right now and have that heard, assuming the court has some process for actually doing that. Hennepin County does. I'm not up to date on it enough to actually give an accounting of how Hennepin handles it, but Hennepin does have expungement hearings, or does have the ability to do that. I believe Ramsey does as well, but I'm not sure, and I'm not aware of the process in other counties. You'd probably have to talk with an attorney who practices and actually does expungements in that county to know, because again, expungements can vary a little bit based upon the county that you're in. But certainly tenants have the ability to file those cases right now. There's no moratorium on it. The only real question in my mind is what process, if any, does the court have in actually hearing it, or going forward with that motion? Would they hear it in person? Would it be over Zoom? Or are they going to have a complete freeze on it? And again, that's probably going to change by county, county to county.
And in the chat, I just pointed out the Minnesota statute that sort of governs housing eviction expungements in the state. All right, any other questions, folks? Feel free to send them in the chat or via the Q&A, or raise your hand and we'll let you talk if you want. Or we will end 13, 14 minutes early for you to go out and enjoy the steamy hot weather. Samuel's in the nice air-conditioned office at Homeline.
I know, I'm encouraging everyone to go outside though with the window to what looks like a beautiful day, although it is very warm.
All right, well, I'm gonna just quickly again put up on the screen, if I can figure this out. There we go. We're done with Q&A, but just a reminder again, there's the info about our weekly webinars. A little slow this week, so I don't have registration up yet, but by the end of the day, you should hopefully get an email from Deb in our office, follow-up email with a recording of today's seminar and a link to where you can register for next Thursday's session, where I think will be Mike Robb, the managing attorney here at Homeline, will probably be back in the hot seat where Samuel is today. Or it's actually,
I'll say it's a very cool seat in the office here.
All right. Okay, well, thank you. I'll just double check the chat. Okay, I think we're good then. So thank you everybody for joining us today, and have a good holiday weekend.
Thank you.
Bye.